Okay, I was, some of us are being interviewed, and it was a charming young man was interviewing me last night for some documentary or something. And among other questions, he said, so how do you deal with the 30 states where parental alienation is not admissible? And the little voice in the back of my head went, what the? And since I've had lots of therapy with Nick Child, I calmly said, where did you get that idea? So since hundreds of years ago, parental alienation has been modeled in the courts in English language jurisprudence. Since Gardner's formulation in 1985 about a parental alienation syndrome, courts across the United States and Canada and in other places have been dealing with parental alienation. Because, of course, decades before Gardner started talking about this, there were other people talking about the same phenomenon in different words. Gardner just formulated it as a syndrome. So his paper in 1986, he was already testifying in 1985. I wanted to do research that would help us understand, well, how common are parental alienation cases in the United States. So we already knew that there are hundreds of peer-reviewed articles about parental alienation, literally hundreds of them, and they're stored, the citations to them are stored in this database. So I created a research project as an attorney first, well, as a forensic psychologist, but I created a research project because I needed to go into court in Georgia, I needed to go to court in Washington State, I needed to go to court in New York, I needed to go to court here, there, and everywhere, in Ontario and Saskatchewan. I needed to be able to say, well, you guys have been dealing with these cases before, and to which I'd get this, huh? So I created a research program at my law firm to answer interrelated questions. How many cases of PA find their way into regional reporters? In other words, where we can actually see what the judge had to say when she wrote her opinion. Have the number of alienation cases each year remained the same? Are they increasing or decreasing? How often do courts identify the gender of the alienating parent? Similarly, how often is the gender of the target parent mentioned? Do the proportions of male alienators to female alienators remain the same, or have the proportions changed over time? Now, I became a psychologist trainee in 1965, and then I went to did a lot of work in psychology, and then I got a scholarship at the New School for Social Research to study for my doctorate, and whereupon the folks said, well, here's a scholarship, by the way, you don't know how to think. Well, what? And they began to reteach me the scientific method all over again, just pounded it into me because after all, it was a New School for Social Research. So spending years with the scientific method and the philosophy of science, and then diverted into some independent studies at an experimental university in the philosophy of science, and spent 4 years doing that, writing a dissertation on the philosophy of science, and then went back and got my PhD in psychology. And so what science is and what science isn't is really important to me. So when I see newspaper articles and blog posts and silly things being said to me like, how do you deal with the 30 states that don't admit parental alienation? I know you've seen that in the provinces in Canada. As a scientist, I go, huh? So, but as a scientist, it's important to me to look at what's there, not to take my ideas about what I think is there and go try to find it, right? There's a current interesting controversy with some new stuff that came out that's supposedly a study where the researchers had an idea and then went looking for it. That's not how you do science. That's not how science is done when you're trying to discuss a phenomenon and what its incidence and prevalence is. What science does is it asks questions like, how many? Where do they occur? Do they occur at all? Are they admissible? So that's what the research study was designed to do. Another goal was to catalog PA cases and provide you with examples of what are the contours of PA, to see if we could find enough cases of PA reported in regional reporters so you could actually read what the judges saw, what they said, what they decided. Well, so we were looking for 20 or 30 cases, and we know that since Gardner in 1985, we started with 1985. And additionally, I had the good fortune to be a Thomson Reuters key author, which means that all of everything that Thomson Reuters has and Westlaw has and all that was available to our research team, which at the time was supported by Mr. Joshi and my law firm. And so we additionally wanted to use Westlaw because Westlaw, being the largest law publisher on the planet, had access to all of these cases. So we developed a query, which some people would call an algorithm. And the query was developed for all states because we can find this in 2013. I published about U.S. and Canadian cases. And I suck so bad at reading French and so many cases from Canada are in French that it was difficult for me to do that accurately. So this time we can find the research to cases in the United States. So the query was developed, and here's the query. We're publishing what the query was. We're not hiding it. Alienate, so any derivation of the word alienate, alienation, alienator, alienating, within the same sentence as mother, father, son, daughter, or parent, parental, parental, parenting, parentified, parentification, after 1984 and before 2019. Okay, very simple query. And then we ran it through Westlaw. We had a bunch of other queries, but there was too much noise and not enough signal. So working with the Westlaw reference attorneys, thanks again to West for their kind support of this research, we refined the query to be simple like this. So what did we get? Well, remember, we wanted to make sure that we got only cases that had the root word alienate, okay? Within the same sentence as these people that are involved in it. So we could try to get to the signal and ignore the noise, okay? So we ran the query looking specifically for the time period since Gardner. Now, we could have gone back. I mean, I talked about cases back in the 40s. I showed you the first slide was cases back in the 1800s. But we wanted to look at what's the impact of the term parental alienation as Gardner used it, not brainwashing, not pathological enmeshment, parental alienation. And so, well, it was kind of overwhelming. We got 3,555 cases. 3,000, and each case is 3, 4, 5, 20, 30 pages long, each case report. This is hundreds of thousands of pages of case reports. So the query brought us 3,555 cases. So we got a digital copy of every case report. We downloaded every single case report in Microsoft Word format so we could search easily in it. So people that are sort of Luddites like me could search through the cases. And we stored every one of those 3,555 cases that the query found in a full electronic folder, cases to be reviewed. So the initial review of 34 years of cases demonstrated that many of them grew out of, all of them grew out of high conflict domestic disputes, as you would imagine. But some of them had to do with dependence and neglect. For example, the kids get taken away and then grandma is alienating the daylights out of the kids so they don't go back to mommy, because she thinks mommy's a drug addict or something like that. So in these circumstances, in these cases, we determined, and I determined as the investigator, that many of the cases and the counterclaims and violations of court orders and allegations of abuse and shared parenting, and all these kinds of allegations were made in these cases, and that there were many different people with many different viewpoints about this stuff. So because the records reflected that these allegations were made by the parties, by their family members, by their witnesses, by their attorneys, by their mental health professionals, the children's mental health professionals, the Children's Protective Services, the court-appointed guardians ad litem, many of these iterations of parental and alienation came into the court record because these people were saying it. They were saying, mommies, daddies, psychologists, therapists, CPS workers, guardians ad litem were saying that there was parental alienation. Well, okay, remember, hello, Demosthenes, here's a scholarship you don't know how to think. Let's spend the next few years teaching you how to do science. So there's a lot of noise here, lots of noise, lots of court opinions where the only iteration of parental alienation is mommy saying, he's an alienating parent. That's it. That's all that's in the case. Okay, so what do you do when you've got a data 3,555 cases like that? Well, it was my sense as the investigator that with the potential exception of CPS workers, the parties, family members, witnesses preferred a particular outcome. Therefore, they were biased in their sense of the case circumstances. Think about it. They preferred they're saying it's parental alienation because they prefer a particular outcome in the case. They're waving this flag, hoping that a decision maker is going to say something different than they would have said before. Well, okay, that's fine, but as a scientist, I'm trying to whittle it down. I'm doing the old Occam's razor thing. I'm trying to get down to, well, what can we say with certainty about what the courts are actually deciding? So, because of these potential biases, I created a very conservative inclusion, exclusion criteria set for the study. Why did I do that? I did that because, to the best of my ability, I wanted this research to be bulletproof. That is to say, just because mommy says he's an alienating dad, or dad's therapist says he's been alienated by, the evil stepmom or something like that, that's fine, but I wanted a more conservative criteria for inclusion into the study. So I adopted a conservative inclusion-exclusion criteria for analysis of the 3,555 cases. So the only cases from the 3,555 cases we found from the 34 years sample time period, the only cases which met one or both of these criteria was included in the relevant cases folder. So remember, we got 3,555 cases to go through. Oh, my goodness. And so we had cases to be reviewed. Then we set up a relevant cases electronic folder and a not relevant cases electronic folder. And the only way you got from cases to be reviewed and got into the bucket relevant cases was if an independent evaluating expert testified on the subject of parental alienation, whether they found it or not. But they came to court and they testified about it. Your Honor, I've looked hard at this, and I looked at competing claims, and in my estimation, I don't think that parental alienation is happening here. Well, okay, why was that included? Because the research is about how many cases of the courts actually dealing with the concept of parental alienation in a way that is not skewed by somebody who prefers a particular outcome. The independent evaluating expert, for the most part, doesn't prefer a particular outcome. So one of the ways that a case would get from the cases to be reviewed and all the way over into the relevant cases folder was if an independent evaluating expert testified on the subject of PA, whether they found it or not. Or the judge found on any basis that there was PA or not, whether or not there was expert testimony. Sorry, I had the dyslexic guy try to read sideways. What can I say? So the other inclusion criteria was that the court dealt with parental alienation on its own, sua sponte, whether or not there was an expert. So, two inclusion criteria, one or the other or both. An independent expert says PA is relevant to examine here, or the court says we're going to look at PA here, whether she had an expert or not. So, remember, for this research, we eliminated and did not include in the included cases the records that only had the parties or the children or their therapists or the children's therapists saying there was parental alienation, or their attorneys, the guardians ad litem, the child advocates, or the mediators, right? Or the parenting coordinators, or the custody conciliators, or law enforcement, or CPS personnel. So in other words, of the 3,555 cases, we eliminated all of the cases where only the parties or children, the therapists, the children's therapists, the attorneys, the guardians ad litem, the child advocates, the mediators, the parenting coordinators, custody conciliators, law enforcement, or CPS personnel said it was parental alienation. Why did you do that, Dr. Lorandos? I did that because I wanted solid deal with it. Because remember, one of the essential questions here is this concept admissible? Because, there's a meme that's developed, and that's why I started the talk by saying what this, polite young man asked me last night. How do you deal with the fact that they're not admissible? Well, are they or aren't they? There are a number of published articles in non-peer-reviewed journals that say, well, it's not admissible. Well, let's find out. Is it or isn't it? So, if the court did nothing more, and we zeroed it in even further, getting rid of more noise. If the court did nothing more than just mention it, I think that maybe parental alienation might be here. Not enough. Not enough for inclusion into the study. Why? Because it's just mentioned in passing. It doesn't. The record doesn't indicate that they really engaged with the concept of parental alienation. Or if the court's action was to appoint an expert to examine the extent to which there may be PA, the case wasn't included in the relevant cases folder. So you can see that the criteria for inclusion is extremely conservative here. So what did we get? Over the research, I trained 6 coders, 6 assistants to go through these cases. Because believe me, when you're going through 3,555 cases, you can sort of blur out. And then you've got to wade through the way courts write up their opinions. It's like, oh my goodness, at times. So who were these coders, these people that were applying the inclusion-exclusion criteria? Well, unlike other people that publish their, quote, studies about this, I'm going to tell you exactly who they were. They were a college-certified paralegal, a junior associate attorney, 3 law school graduates who were awaiting their bar exam results, and a third-year law student who had attained a doctoral degree before she even went to law school. Okay? And of these, 3 were male, 3 were female, and they got all the cases blind. They didn't know which cases they were going to get. Here's a chunk for you, here's a chunk for you, here's a chunk for you, a chunk for you, all blind. So, gender, I dealt with gender, I dealt with age, and I dealt with background. Okay, so they reviewed these cases, and all of the cases that went into the inclusion bucket, we created an annual tally sheet, and then we checked the case citation. So for all the 1985 cases, we had a 1985 tally sheet of the included cases. We made sure that the citation was Blue Book perfect. Why did we do that? We did that because we're giving it to you. We're publishing the database. We're giving it to you. We're not hiding it. We're not pretending. We're not saying it's proprietary. We're giving you the results. You're going to get every single case that we found. So every case was then pasted into its annual tally sheet year. And in the cases, as we went through the cases, we tried to designate on the tally sheet for that year what was the gender of the alienator. Was it a man? Was it a woman? Or if the court wasn't clear about the gender of the alienator, we'd mark other. So we looked at the gender breakdown: males, females, others. Now, others also included where you have two dads or two moms. So for the most part, where we had two dads or two moms, we didn't necessarily code it as male alienator, female alienator, because we were looking at primarily at the dichotomous gender families. So each yearly tally sheet had the number of female alienators, the number of male alienators, the number of non-determined alienators, and the number of custody changes. Okay, and the proportion. So this is on each annual tally sheet. So remember, 3,555 cases to review. Big bucket. Bucket. Whoops. Bucket didn't make it through the inclusion-exclusion criteria. Just a CPS worker said it, or mom's therapist said it. Not going to get into the last bucket. The bucket where as much noise was taken out and only signal was left that made it through the inclusion-exclusion criteria. And if they did, was it a male alienator, a female alienator? Was it non-determined? And was there a custody change? Okay, so we tallied these. We went through all of the stuff and put them into the different folders. And each case that didn't make the inclusion-exclusion criteria got stuck in the non-relevant cases folder. Okay, so the case report was relocated to the relevant cases folder if it made it through the inclusion-exclusion criteria, right? And a summary of each case was developed for another publication. And the case citation format was checked with Blue Book of legal citations, and the tally sheet was doubly corrected. Then we made sure that we had the designation of male or female alienator if the court identified it that way on the tally sheets. So if the court ascribed equal responsibility for alienation, or the case report was unclear as to the gender of the alienator, the male-female designation was left as other. So only the cases where the court said the alienator is a man, or the alienator is a woman, or words to that effect, were the cases coded male and female. Everything else was other. So when a case was selected, we looked at whether there was a substantial change in custody or the custodial environment. And what we mean by that was, for the purposes of this research, this substantial change in the custodial environment was defined as parenting time allocation after the parties were in court was substantially different than before the parties were in court. So in other words, if dad goes in and he's got nothing at all, and he comes out with 50-50, the custodial relationship has been substantially changed. He didn't walk out of the court with sole custody and mom doesn't have anything because she's an alienator, but that was a substantial change in custody. If the percentage of overnights changed dramatically, that's a change in the established custodial environment. So we coded it for that. So the master tally sheet was developed for all of the included cases. So 3,555 cases, all the ones with too much noise and not enough signal here. All the included cases here on an annual tally sheet designating male, female, other, substantial change in custody, proportionality, etc. 34 annual tally sheets were then built into the data from the annual tally sheets was put on a master tally sheet 1985 through 2018. And it was 2018 because when we finished this research, we were finishing this research for the book. We wanted to make sure that we got as many cases as we possibly could, and some state reporters get them in late, so we cut it off at December 31st, 2018, even though we knew that the book would be published later on. And this article has been requested for a special issue of a journal that's coming out next year, which you will also get. So So the query was alienate mother, father, son, daughter after 1984, before 2019, 3,555 cases. And the inclusion-exclusion criteria found this bucket has 1,181 cases. What does that mean? What does it mean that there are 1,181 cases that made it through this intensely conservative inclusion-exclusion criteria? Well, I would suggest to you that the inclusion-exclusion criteria, when we ran the query for alienation within the same sentences, mother, father, son, daughter, and parent, that the operation of the inclusion-exclusion criteria was so conservative that it dumped 67% of the cases out. Too much noise, not enough signal. Dumped them out. And some of my researchers said, but Doc, we're reading all these things and you know, 67% of these cases you're not letting us put in the database. That's right, I'm not letting you put them in the database because we're sticking to an extremely conservative inclusion-exclusion criteria. Okay, so we did statistical analysis on these cases. Next figure I'm going to show you shows the number of parental alien cases in trial and appellate courts in the United States between 1985 and 2018 that made it through the inclusion-exclusion criteria. This graph I'm going to show you indicates that the number of cases has grown over the years. So one of the questions that we asked was, has it stayed the same? Is it going away? Has it increased? We wanted to know what's been happening. We didn't develop an idea and then go searching for support for our idea. That's not science. We asked questions. Are there any? Do they get admitted? Are they substantial? And we looked at the data to see if they were actually out there. And indeed, we see, holy Toledo. I don't know what happened this year. Maybe it's like some sort of an economic problem, but you can see that the trend line, is dramatic and increasing in the last 34 years. The trend line shows parental alienation cases in the United States increasing dramatically over time. So in our statistical analysis, we developed another figure. It shows a proportion of cases each year involving female alienators versus male alienators and other alienators. During the graph that I'm going to show you indicates that between 1985 and 2018, remember we've heard in conference after conference, this is a phenomena that knows no gender specifics, and men do it and women do it. Okay, so we wanted to know, well, okay, what are the courts saying? If a hypothesis was, it's gender neutral. The courts are finding just as many alienating dads as alienating moms. Our hypothesis was that it's gender neutral, just as many alienating moms as alienating dads. Well, that hypothesis was dramatically falsified. It's dramatically falsified because what we see here is that 23% of the court-identified alienators' gender were males. 23%. 14% were others. We couldn't be specific. 63% of the identified by the court, not by me, not by the research assistants, were females. If we drill down into the other, we would see that it's probably about two-thirds, easily two-thirds, one-third, females to males who were found by the courts, not by me, but by the courts. Remember, we're searching for what is out there, and we are reporting on what is out there. We are not looking for what we want to find and then trying to get cases to support that idea. That's not science. We're looking at what did the courts say in this 34-year period. So this next graphic has to do with how often is there a substantial change in custody. So this figure shows that in 61% of the cases, there's a substantial change in the custodial environment. Just because there's parental alienation that's relevant in the case doesn't mean that the court's going to change custody or make dramatic changes in the custodial environment. But in 61% of the cases over 34 years, a substantial change in the custodial environment is made when parental alienation is considered by the court. Okay, well, why is this important? We know that a meme has developed that PA doesn't exist. In contrast to the scientific and legal literature describing PA behaviors in a number of published articles, book chapters, there are a number of chapters and articles and websites that say the concept is bankrupt, the courts don't believe it, and it doesn't exist. So we set up another hypothesis. It doesn't exist. Falsified. It does. Courts don't look at it. Falsified. They do. So between 1994 and 2018, we find a wholesale attack on the concept of parental alienation. There's another chapter here in the book that's coming out that it should be published in black and blue because Dr. Burnett beat the ever-living snot out of me to rewrite this chapter over and over and over again about the admissibility of the concept, okay? And that's corollary to this research. So the concept of parental alienation between 1994 and 2018, we find notes in bar journals, law students and social workers and so on and so forth, nurses. Curiously, we find disbarred lawyers, suspended lawyers, law school teachers, law students writing about science. And we find psychologists, social workers, psychiatrists writing about law. I love it when social workers and psychologists and psychiatrists tell me as a lawyer what admissibility means, what relevance is, what standards of proof are. I work really hard. I'm going to have to pay Dr. Child all the money back for all the therapy that I got for trying to calm me down, because I get a little bit ballistic. And then when I have law professors and disbarred lawyers and suspended lawyers and such telling me, well, the science says, I worked really, really, really hard to survive, the philosophy of science. And it just irks me that they're telling me about what science is, because remember, lawyers, apologies, Brian, and social scientists speak different languages, and we're often going past each other in the night. So, knowing that there are many social workers, nurses, psychologists, law professors, disbarred lawyers, etc., that say doesn't exist, it's a BS concept, we wanted to know, well, how are the courts dealing with it? And we found that analyzing 3,555 cases demonstrate that experienced jurists, litigators, mental health professionals across the United States are increasingly recognizing the construct of PA, as well as its materiality, relevance, and admissibility in determining child custody disputes. This is really important because for parental alienation detractors, their meme of unreliability, it's noteworthy that of the 3,555 case reports, they document a family court judge changing custody at times, doing substantially important things to families because of this concept of parental alienation and its activation in the case. But let's just go back there for a second. One of the things that I particularly find troublesome is when the folks that develop these memes say, well, parental alienation is merely a plot. It's a strategy to take children away from, I love this part, protective moms and give them to abusive fathers. there's a new, quote, study out that says that when women make allegations of abuse, they lose custody. Well, what the researchers, and that's probably true, because when the courts look hard at allegations of abuse, and they always do, there's no judge anywhere that if you say somebody's abusing somebody, she's not going to look at this hard, because her job is to protect the children. So it's radically insulting to suggest that when women make allegations of abuse, they lose custody because the judges got it wrong. No. No. As a lawyer, I'm offended by that. As a child advocate, that offends me. It offends me on behalf of all these judges because the data shows they look really hard at that. And so I'm here to tell you that not one case in the 3,555 cases that were reviewed found a judge taking a child away from a protective mom and giving him to a physically abusive dad. That's just not in the data. Okay, so what else do we see in the data? We see that together with the fact that 25% of the 1,181 cases returned in the search involved male alienators and female targets, female victims. There's plenty of you in this audience. You are women, you are victimized, your target parents. So this refutes the claim of some deniers that parental alienation is no more than fabricated by male perpetrators of intimate partner violence. Not true. Not what the data shows. Okay? So contrary to the negative memes that I just described, courts across the United States seem to agree with the research in the 8 behavioral manifestations of PA in the children and the cluster of symptoms and behaviors indicating the presence of alienation in the child can be reliably identified and reliably described. So, of 1,181 cases, many were unpublished. Why is this important? Well, it's important because the case facts in these reports that are not published, they're cited as unpublished, are horrific. And they don't want to put this bad news out into the world. Also, we find that in many of these cases, courts change the initials, change the name of the parties to initials. So it further anonymizes cases. So is the fact that a case is not published, does that mean that it should come out of the database? No. If it's findable, and we can see what the court did in her wisdom when she dealt with these competing issues of parental alienation, that's valuable. We want to know what happened there. So just because they have initials or they're anonymized doesn't take them out of the research study. So, but wait, here's an important digression. Every one of the 1,181 cases which made it past the inclusion-exclusion criteria for the study dealt with parental alienation. Otherwise, it wouldn't have made it past the inclusion-exclusion criteria. Every one of them. If the court determines that they need expertise, and this is how courts decide. This is the old if-then thing that lawyers are so fond of and lawyers and philosophers are so fond of. If the court determines that the expertise of this sort is needed, in other words, discussion of parental alienation is needed in the case, and the proposed witness is actually an expert, and what the expert is offering is material to the issues in the case, and what the proposed expert has on offer is probative of a fact and issue, and the proposed testimony is also relevant, and the proposed expert evidence should not be prohibited because it may be more prejudicial than probative, then, and only then, will it be deemed admissible. Let's go through that again, boys and girls. Because, if I still got time? Am I good? Okay. Remember, when you're discussing whether this concept is admissible or not, there's a tough row to hoe to get into admissibility for the most part. And this is how they make a decision. If an expert of this sort is needed, and if the proposed witness is really an expert, and what the expert is offering is material to the case, and what the proposed expert has on offer is probative of fact and issue, and the proposed testimony is also relevant, and the proposed expert testimony is not prohibited because it's more prejudicial than probative, then, and only then, is it admissible. So come on, evidence fans. It's got to be material. Materiality concerns the fit between evidence and the case. It looks at the relationship between propositions for which the evidence is offered and the issues in the case. And it had to be probative. Probative value is in common law tradition has been defined as evidence that tends to prove or disprove a point and issue. And it had to have been relevant. It has a tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. So if it's material, probative, relevant, it's admissible. 1,181 times. What are the limitations of the study? Well, first, for the most part, these cases come from appellate reports. It's staggeringly expensive to get to an appellate court. We looked really hard. I think we gave West reference attorneys hemorrhoids trying to figure this out with us. We tried algorithm after algorithm after algorithm to figure out how, if we have this many appellate reports, how many cases were actually handled in the trial courts. That's really difficult to figure out. We'd really like to know that. But so this research is limited to the cases we could find through appellate reports and through published trial court opinions. The study was also limited because it's so tremendously expensive, and there are very few trial-level court opinions that are available online. Some states do it, most states don't. Also, it's important to note that the residual impact of patriarchy is probably active here because women have to work much harder for the same pay that men get, and disposable income among female and male litigants is really skewed in many cases. So the residual impact of patriarchy must be considered when we're looking at these percentages and who can afford to litigate. Fourth, the inclusion-exclusion criteria may be too restrictive because when I talk about this or when I publish the preliminary findings, people come up to me and they say, Doc, you're underreporting. You're dramatically underreporting. First of all, how many cases make it to the appellate court, right? You're dramatically underreporting. And there are numerous cases where the query didn't find them because the reviewers would have qualified as PA or PA related, but they didn't use the term alienation, so the query wouldn't have found them. For example, in Doe versus Roe, the court and its evaluators found the mother to be at times untruthful, willing to make repeated false, unsupported allegations, willfully disobedient, perhaps a malingerer, and ultimately incapable of proper parenting of her child. The mother hired a psychologist to support her claims, but the trial court rejected these and placed sole custody with the father and ordered that the mother's contact be supervised, writing inter alia. The mother's expert also effectively undermined the mother's cooperation in therapy. The mother's expert did not hesitate, without ever communicating with the evaluator in the case, to reinforce mother's distrust by opining that she did not believe that the evaluator had a clear handle on the child, and for her to offer such unilateral opinions based on only a record review undermined her credibility, unquote, the trial court. Well, there were many cases like this. The alienation query couldn't find, because when you're reviewing case reports, most readers would find, let me back up, I'm trying to go too fast. There are many cases like this, and reviewing many cases like this, we would have put it into the included cases because they're clearly parental alienation behaviors. But they didn't use those terms, so the inclusion-exclusion criteria excluded them. Another example of perhaps underreporting. If you look at, LS versus CT, or Terenskaya versus Vodolarski, or KM versus SMM, or Dominiconi versus Dominiconi, or Marks versus Schenck, this is particularly enjoyable since the psychologist that did all these cases did this one right in her own backyard, and the judge threw her out and said she was dishonest. Okay, well, the behaviors that this psychologist came in to champion on the part of alienating mothers were outrageous, and they'd all be coded as parental alienation cases, but they didn't use the term, so it didn't make it into the inclusion. So, what does this data tell us? Parental alienation, the concept is material, probative, relevant, admissible, over and over and over and over and over and over again. So the idea that it is not admissible is falsified. The data tell us that this is relevant to refuting the memes that it's not admissible and it's a junk science concept. Can we use this data? Absolutely. This is what the courts say. Put it in the brief. Put it in the brief, because there's a ethical code of conduct for lawyers. You cannot purposely misrepresent facts or law to the tribunal. That's a pull your ticket offense. You get in there and you lie to the judge, you purposely misrepresent stuff, you should have your bar license suspended, right? So if you have somebody in court saying, well, this isn't admissible and it's junk science, that's a purposeful misrepresentation to the tribunal, because it is. So we can see where these cases happened, when they happened, how they develop across time. So what are the limitations of the study? Well, we've talked about the impact of patriarchy, the impact of only appellate court opinions. There would have been maybe many, many more, but I can't understand how to develop an algorithm that would help us find, if we have this many appellate cases, it's likely that there were this many trial court opinions, but they just were exhausted of funds and couldn't appeal. So what should we have done differently? Well, maybe we should have got a grant, because boy, oh boy, this is expensive and it took a long time. But, you know, I get hired to be an expert and I go do testimony, and then the money I get paid gets put into this research. So, and we're going to talk about it in great detail in this book, because we spent a long time writing this for you. This entire research, every single case of the 1,181 cases with the correct citation is available to you in the appendices in this book. Every single case, the algorithms, everything we used, all of the coding, everything is available to you. And there's other stuff available to you too, but you don't need to worry about that now. Just suffice it to say, thank you.